Welcome back. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people get the compensation they deserve for their injuries. Today, we're talking understanding occupiers' liability claims. I'm going to talk about what this is and 3 important things to know to understand this type of lawsuit. First of all, what are occupiers' liability claims? An occupier's liability claim is a legal action against a property owner or occupier for injuries that occur on their property due to their negligence. Some common examples include slipping on icy stairs or tripping on uneven ground. If successful, the injured person can receive compensation for pain and suffering, medical expenses, lost income, and various other things. I do have a video specifically about the types of damages that you can claim in a lawsuit if you're injured, and that will be linked below. But today, let's get into this Occupiers Liability Act. 3 things that you should know. So first of all, the Occupiers Liability Act in Ontario is the law that governs this type of injury action. It covers various things such as who is an occupier. This can be a property owner, a tenant, or anyone who's in control of the property. The Act also has a definition of premises, and this includes land, buildings, structures, and even some vehicles. What is the duty of care? This is also outlined in the Act, and occupiers must keep their premises reasonably safe for visitors. So the duty of care really is one of reasonableness. The Act does contain some exceptions that you should be aware of. There are exceptions such as injuries to trespassers or injuries occurring during criminal activities. So say someone is breaking into a property and is injured, that would be a specific set of facts that may or may not be covered with negligence law. The Act also speaks about contracts and liability and how special contracts can affect liability. The Act further gets into landlord obligations and specific duties that landlords have as an occupier. The Act also speaks to public warnings, where occupiers must warn the public about potential dangers on the property if they are exempt from certain duties. The second thing to know, apart from the Occupiers Liability Act itself governing these types of injuries, are the common hazards leading to claims. So it is good to be aware of what types of hazards lead to claims. So occupiers must keep areas like stairs, parking lots, sidewalks, ramps, driveways, and aisles safe. Hazards that often lead to accidents include things like accumulated snow and ice that hasn't been dealt with, uneven surfaces, so cracks in walkways or potholes, poor lighting that can contribute to an accident, slip hazards such as wet floors or spilled liquids or fruit even on the ground that is slippery, tripping hazards, loose debris can be a hazard, unmarked changes in elevation, so things like unexpected stairs or steps or drops in the ground, as well as broken stairways and missing handrails. Inadequate safety measures are also types of hazards that can lead to these claims, so things like slippery tile floors without grips. Occupiers must take reasonable steps to fix these hazards, or at a minimum must warn people. So using something like that yellow foldable caution wet floor sign. However, warnings alone may not eliminate the liability entirely. The third important thing to know about Occupiers Liability Act claims is who can be held liable. Liable parties can include landlords, store owners, hotel owners or property managers, restaurant owners, or private homeowners even. A thorough claim should identify all responsible parties. Compensation can cover pain, suffering, medical bills, lost wages, and more. So it is really important that you consult with a lawyer if you have sustained an injury and you think someone was negligent. You should talk to a lawyer about it, and I would be happy to discuss this and give you some advice about next steps. My contact information is below.